Richard Apat. I'm a partner with the firm of Perlman, Apat, Futterman, Sorokin, and Seinfeld. The types of cases that I handle are mostly personal injury, from anything from your average automobile accident case to scaffold accident cases, employment-related accidents, product liability, and any way in which somebody might be injured as a result of the negligence of another person or another corporation. We generally handle cases where people have been fairly significantly injured. It's not always easy to tell that somebody has been seriously injured. Oftentimes people can have injuries which at first blush might not appear that significant, but over time and in the course of treatment turns out to be much more serious than people first thought. In addition to that, we research cases from a point of view of liability. Just because somebody is seriously injured does not mean that they can recover. Sadly enough, we've had many cases we've had to turn down where people have been killed and there just frankly was no party that was liable for the event. So from that point of view, we need to make sure we do investigation and determine under the laws of our state that some party or corporation is liable. And finally, after that, you need to make sure that there's somebody that can pay. Hopefully there's insurance coverage. And that's generally who we turn to when it comes to the corporation or the negligent party to seek the recovery from. Approach is very much working from the end backwards. Sometimes you can get caught up with people's stories. Let's face it, we do personal injury. We hear some horrific stories. If you just listen to the story and get so taken in by it that you're not focusing and keeping your eye on the ball, it could have very devastating results. You can put a lot of time and energy in it, get people's hopes up, and ultimately not have a recovery. So the way I work is from the end backwards. I make sure, assuming what the client has told us is accurate, assuming what the investigation shows is correct, that if all these things line up, will there be ultimately a recovery for our client? Will there be a payday? It's beautiful when you can take a case on principle that also lines up with a case that's economically feasible to pursue. You don't always have that opportunity. So number one, primarily, we make sure that the law supports our client's claim, that there are theories of liability which will result in either a verdict or a settlement for a client, and then we work backwards from there. There's no substitute for lawyers who work with doctors on a daily basis at the highest levels. And the reason why you need to work with doctors at the highest levels is because a jury is not going to be convinced by a low-level or average credential doctor trying to explain something. He or she is just not going to carry the weight. I tend to under-promise and over-deliver. I research things extensively before we jump into a case, especially if it's something that's somewhat out of the ordinary. We do not get paid simply for processing cases. We only get compensated if our client gets compensated. So when you earn a living that way, you handle things differently. You kind of work from the end back. You make sure that everything about the case is credentialed. You find out about your client. You find out about the defendant. You find out to make sure that once you win the case that you can actually collect on the case. And I just think there's a different approach to people that earn a living mostly by making sure that they get a recovery for their client, as opposed to another type of attorney who's retained on an hourly basis. And regardless of the outcome of the case, they're going to get paid for putting time in on that case.